वेलकम बैक टू द चैनल दोस्तों। बड़ी इम्पॉर्टेंट सर्कुलर जो यहाँ पे इन रिलेशन टू द जो हमारा केस पेंडिंग है हॉनरेबल सुप्रीम कोर्ट ऑफ इंडिया में लिखा गया है बाय मिस्टर के बी आचार्य जी, AIB पाक। तो पूरा मैटर है क्या दोस्तों? AIB पाक IBA टू द चेयरमैन इंडियन बैंक एसोसिएशन, ex gratia paid to pensioners, family pensioners of the banking industry, and MOU signed on 7 December 23, 12th BPS note signed on 8th March 2024. So we have instantly conveyed our note of discontentment on IBA and United Pharma Bank Union. इसको देखेंगे क्या है. So why is AIB Park in principle and philosophically opposed to the concept of ex gratia? The word ex gratia means a payment जो एक फेवर में दोस्तों करी जाती है, and this is a voluntary payment which is the not a part of institution legal liability. So IBA and United Pharma Bank Union has already indulged in grant of ex gratia to lower ranked pensioners while extending the benefits of 100% neutralization of DA to pre-November 2002 retirees. So that ex gratia was not meant for those pensioners who were already enjoying the benefit of 100% neutralization of DA. So it was thus behind human comprehension as to why the IBA, that is stubborn in refusing implementation of pre-existing Regulation 35(1) or BEPR 1995, was so gracious to extend an ex gratia and inconceivable benefits to a section of pensioners and thereby create an anomalous situation arbitrarily. So this is well known to the signing parties of the MOU and the settlement that the ex gratia in banks is paid to persons who retired prior to 1st November 1986 and who are denied to be eligible to get pension. So in the given circumstances, ex gratia is now paid to pre-1986 retirees, pre-November 2002 retirees, and all the pensioners who have retired up to 31st October 2022. So what makes the term ex gratia highly ridiculous in the context of bank pensioners is that there has been no scientific basis to determine its quantum and applicability to the retirees of different periods. So the least expected from IBA was to avoid ex gratia and the consequential illegality and irrationality. AIB Park and CBPRO, through endless correspondence with IBA, have repeatedly insisted that Regulation 35(1) Appendix 1, duly amended in the year 2003 and gazetted by Government of India, provides us the updation of pension, and what was required to settle the issue is that IBA should have notified the updation formula in respect of each BPS as done in case of RBI and NABARD. But IBA, instead of doing the legitimate and fair thing, continues to rant blatantly and ironically that there was no provision for pension updation in BPR 1995. Under such circumstances, we suspect so what has been the response pattern of IBA and constituents of United Pharma Bank Union after signing of MOU and before signing of the settlement and joint note? सो इसका आंसर भी यहाँ पे दिया हुआ है दोस्तों. Although we don't have anything in writing, we had oral queries to various key persons of both the parties to the MOU. A common impression was made available to us. The serving organizations of employee and officer have made a lot of sacrifice for the retirees. IBA is working out a formula and the amount given as ex gratia will not be at all bad or insignificant. तो ये सब आंसर्स हमें मिले हैं. However, when we landed on the ground of reality, we came to understand that it was a well known, thought of, and uniformly orchestrated audio to hoodwink the retirees. So we are really perplexed to think of the reasons acting behind such a mysterious exercise, which was kept deliberately under a veil of secrecy for a period of 3 months. So this hide and seek game with the senior citizens of industry, despite all concerns and sympathetic approach exhibited to us by the Honorable Prime Minister, is unfortunate to say the least. So our observation to point A above is we did not want any sacrifice for ourselves, because if pension updation was allowed as per spelled out provisions of BPR, then the entire amount could have been charged to the existing corps, which in our opinion is self sufficient. Other observation to point number B above is we are curious We are curious to know if the process of calculation was done unilaterally by IBA, or the constituents of United Farmer Bank Union had any say in it. So our observation to point C, IBA was surely aware that it has been a rude mockery for a huge number of retirees who have superannuated on or after 1st of November 2012 and hit by non-reckoning of special allowances for computation of पेंशन. सो स्पेशल अलाउंस तो बहुत बड़ा इशू है दोस्तों. If any issue is sub judice, can there be no bilateral agreement between IBA and United Farmer Bank Union over the said issue? Is it not a lame excuse? सो इसका जो आंसर यहाँ पे दिया है दोस्तों आप पढ़ सकते हैं. You could have resolved the issue by implementing Regulation 35(1) in letter and spirits, making way for the petitions in the Honorable Court to become in practice. What further issues of discriminations have been created in the process? So in the settlement, there is a mention that the new dearness relief calculation formula is applicable for those who retired after 1st November 2022. So this has give rise to two set of DR calculation formulas based on the respective dates of retirement, and it has been done with a further few months after removal of discrimination that existed between pre-November 2002 retirees and the subsequent one. So it needs an immediate examination at your end and rectification measures be taken. So we have already drawn your kind attention to the aforesaid subject by our earlier letter dated 14 March 2024. सो दोस्तों यहाँ पे आप देख सकते हैं काफ़ी लेंथी सर्कुलर है, बट वी हैव डन आवर बेस्ट. रिव्यू ऑफ एक्स ग्रेशिया इज़ ऑलरेडी ड्यू, वो आपको पता ही है, इसकी वीडियो हम लोगों ने ऑलरेडी शेयर कर दी है. So this is the circular that has been written by सुपीता सरकार जी, मिस्टर KB आचार्य जी. So kindly read जो भी बचा है इसमें. So with this, that's all for this session.